Welcome to Law and the Machine, where artificial intelligence meets the legal system, liability, regulation, intellectual property, and the government's uncomfortable role as both rulemaker and AI adopter. The law wasn't written for this.
Major book publishers, the titans of the literary world, are suing Meta platforms, alleging that the tech giant used millions of pirated books to train its Llama large language models. This isn't about Meta accidentally scraping some questionable corners of the internet. The claim is they knowingly used data from a notorious shadow library.
That's right. The dataset in question is Books 3, a dataset widely known to be sourced from Library Genesis, or LibGen. For anyone unfamiliar, LibGen is effectively a massive, unauthorized digital library, a repository of copyrighted works made available for free. The publisher's complaint is explicit. Meta allegedly ingested this treasure trove of pirated content to build foundational AI models.
So Meta, a multi-billion-dollar corporation, is accused of building its AI on the back of what amounts to digital book piracy. That seems like a pretty clear-cut case of copyright infringement on the face of it. What core legal argument is Meta expected to present?
The expectation is that Meta will lean heavily on the fair use defense. It's the central pillar in many AI copyright cases right now. They'll argue that training their AI models, even with copyrighted material, constitutes a transformative use, meaning the AI isn't simply reproducing the books, but learning from them to generate entirely new content.
That's a fascinating and deeply unsettling starting point for such a high-profile case. It really lays bare the tension between established intellectual property rights and the seemingly insatiable data demands of generative AI.
Indeed, the plaintiffs here are the big five publishers: Penguin Random House, Hachette, HarperCollins, Macmillan, and Simon & Schuster. They've united to take on Meta in the Southern District of New York. Their core contention is that Meta engaged in wholesale copyright infringement by copying entire books without permission to train Llama, thereby creating what they see as derivative works.
Wholesale copyright infringement is a strong phrase. It implies a deliberate, systemic approach to using copyrighted material. But for listeners who might not be deep into the weeds of AI development, could you explain what it means for an AI to be trained on these books?
Think of it like this. An AI model like Llama doesn't just read a book and then recite it back. It processes vast amounts of text to identify patterns, grammar, syntax, factual relationships, and stylistic elements. It learns the statistical probabilities of how words and phrases connect. So, when you ask Llama to write a story in the style of a specific author, it's drawing on those learned patterns, not directly copying sentences or paragraphs from a book it was trained on. The publishers, however, would argue that this learning process, by its very nature, requires making unauthorized copies of their works, even if those copies are then transformed into statistical weights and parameters within the model.
And the specific source of these books, LibGen, makes this particularly thorny, doesn't it? It's not just that Meta might have scraped copyrighted material, it's that they allegedly sourced it from a platform explicitly dedicated to illicit distribution.
Exactly. The provenance of the data is a critical detail. LibGen has been under legal scrutiny for years, facing lawsuits and injunctions from publishers globally. Its content is notoriously pirated. If Meta knowingly utilized a dataset derived from LibGen, it complicates their position significantly. It suggests a certain disregard for copyright norms, even as they develop technologies that are supposed to operate within legal frameworks.
It's one thing to argue about the transformative nature of AI when the data comes from legally ambiguous sources, like public web crawls. It's another entirely when it's allegedly from a known pirate haven. It almost feels like a deliberate choice to leverage a gray market for foundational training.
It certainly raises questions about due diligence and ethical sourcing. For the publishers, this isn't just about the act of copying. It's about the erosion of their ability to control and license their intellectual property. They argue that if AI developers can simply ingest entire libraries of copyrighted works without permission or compensation, it fundamentally undermines their business model, especially as the demand for AI training data grows. They see a future where the licensing of their content for AI training could be a significant revenue stream, and Meta's actions are preempting that.
So their argument isn't just about the current impact, but about the future market for their content in the AI economy. It's a preemptive strike almost. They're trying to establish the ground rules for this new form of digital consumption.
Precisely. They're seeking not only damages for past infringement, but also an injunction to prevent future unauthorized use. This is a battle over who gets to monetize the intelligence embedded in human creativity and at what cost.
Let's turn now to Meta's likely defense, which was mentioned earlier, fair use. This is often the legal equivalent of a Swiss Army knife in copyright cases. Could you explain how fair use might apply here, especially given the shadow library angle?
Fair use is a legal doctrine that permits limited use of copyrighted material without acquiring permission from the rights holders. It's often determined by 4 factors: the purpose and character of the use, the nature of the copyrighted work, the amount and substantiality of the portion used, and the effect of the use upon the potential market. Meta's strongest argument here will undoubtedly be the transformative use aspect, falling under the first factor.
Transformative use feels like the linchpin. Could an example be provided of what the courts have previously considered transformative?
The classic example often cited by AI developers is Authors Guild v. Google, the Google Books case. In that instance, Google scanned millions of books to create a searchable database and display short snippets. The courts ruled that this was fair use because Google wasn't trying to replace the books. It was creating a new transformative purpose, a research tool that facilitated discovery without offering a full read-through. Meta will likely argue that Llama is similar. It's not a substitute for reading the books, it's a new tool that generates different kinds of output based on its learning.
So the argument would be that Llama is a learning machine rather than a copying machine. It's like a student who reads a library of books and then writes their own essay, rather than just photocopying chapters.
That's the analogy Meta would likely push. They'd contend that the purpose of the copying isn't to reproduce the original work for consumption, but to extract abstract knowledge and patterns, which is then used to create new expressions. The output of Llama, they'd argue, is fundamentally different from the input books.
But what about the other factors? The nature of the copyrighted work. These are highly creative, protected works. The amount used, entire books. And the potential market impact, which the publishers are already screaming about. How does Meta address those?
Those factors would typically weigh against fair use. Creative works receive stronger copyright protection than, say, factual databases. Using entire books is generally a red flag, and the market impact argument is central to the publisher's case. However, if a court finds the use to be highly transformative, that first factor can often outweigh the others, particularly the amount and substantiality factor. It suggests that even significant copying can be fair if the ultimate purpose is sufficiently new and doesn't directly compete with the original.
That's where the recent Andy Warhol Foundation v. Goldsmith case might throw a wrench into Meta's plans. That ruling seemed to emphasize market harm and a stricter interpretation of transformative.
It absolutely does. In the Warhol case, the Supreme Court ruled that Warhol's use of a photograph to create a silkscreen portrait was not fair use. The key was that both the original photographer and Warhol's foundation were licensing the image for commercial purposes, specifically for magazine covers. The court found that Warhol's use was not sufficiently transformative because it served a similar commercial purpose, thus competing with the original work's licensing market. This is a crucial distinction. Publishers will argue that Meta's AI, by generating content that might mimic or even compete with human-authored works, is directly impacting their licensing market, similar to the Warhol scenario.
So the question isn't just, is it new, but does it serve a similar commercial function to the original, thereby potentially harming its market? That could be a significant hurdle for Meta, especially if the AI is trained on fiction and then generates fiction.
Precisely. The publishers will argue that Llama is designed to generate text that could directly compete with human-authored books, articles, and other creative content, which directly impacts their revenue streams. This is the heart of their market harm argument.
This program often highlights the tension between innovation and accountability, often where the lines between rulemaker, contractor, and lobbyist blur. This case, while seemingly about copyright, reveals a deeper conflict of interest for Meta.
It does. This week's discussion examines Meta's public positioning versus its alleged private actions. Meta, like other major tech companies, has been a very vocal proponent of responsible AI development, investing in ethics research, publishing principles, and engaging with policymakers on how to safely advance AI.
Right, they present themselves as leaders in ethical AI, advocating for guardrails and thoughtful development.
Yet the core accusation in this lawsuit is that the foundational data for one of their flagship AI models, Llama, was sourced from a platform explicitly designed to skirt copyright law. This creates a significant dissonance. On one hand, they advocate for a responsible future for AI, and on the other, they allegedly rely on a Wild West approach to data acquisition.
So the conflict isn't necessarily a government contract, but a deeper ethical and strategic one. They're simultaneously trying to shape the regulatory landscape for AI, often advocating for more flexibility for tech companies, while allegedly operating in an area that seems to ignore existing legal frameworks.
It's a prime example of companies attempting to write their own rules by acting first and then shaping the public narrative around innovation and responsible development to justify those actions. Their use of LibGen, if proven, suggests a willingness to cut corners on data acquisition, while simultaneously seeking to be seen as a paragon of ethical AI. It allows them to quickly build powerful models without incurring the significant licensing costs that would be associated with legitimate data acquisition. This choice entrenches a particular, cost-optimized, and potentially legally precarious method of AI development as the default standard.
It's almost as if they're saying, we'll worry about the ethics and the rules once the powerful models are already built and deployed.
Exactly. And the publisher's lawsuit is a direct challenge to that strategy. The pointed question for listeners here is, when a major AI developer relies on explicitly illicit sources for its foundational training data, while simultaneously advocating for responsible AI frameworks, who ultimately bears the cost of that ethical inconsistency?
That's a stark question, and one that resonates far beyond just copyright law. This case is truly a pivotal case, with immense implications regardless of the outcome.
The stakes couldn't be higher. If the publishers prevail, it could fundamentally alter the economic model for AI development. Training large language models would become significantly more expensive, requiring extensive licensing agreements with content creators. This could favor larger companies with deep pockets or lead to a more centralized AI ecosystem, as smaller players might struggle to afford the necessary data.
And that could be a double-edged sword, right? On one hand, it might ensure creators are compensated. On the other, it could stifle innovation by creating higher barriers to entry for new AI developers.
Precisely. It creates a new form of data gatekeeping. Conversely, if Meta wins, it could be seen as a green light for AI developers to broadly use copyrighted material, arguing that their use is inherently transformative. This would significantly weaken copyright protections in the digital age and potentially devalue creative works.
That sounds like a disaster for the creative industries. Imagine trying to make a living as an author or artist if your work can be freely ingested and used to train models that then generate competing content without any compensation.
It would force a radical reevaluation of creative compensation models. This lawsuit, along with others like Getty Images against Stability AI or the New York Times against OpenAI, are all part of this larger legal and cultural battle. It's the Empire Strikes Back moment for traditional content industries, pushing back against the perceived appropriation of their lifeblood, their content, by the new AI titans.
It really encapsulates that title. This isn't just one lawsuit. It's a concerted effort to establish boundaries. The legal system is playing catch-up, essentially,
The courts are tasked with applying centuries-old copyright principles to technologies that were unimaginable when those laws were conceived. The outcome of this case will send ripples across the entire AI ecosystem, defining what is permissible and what is not in the quest for artificial intelligence.
To conclude, what key insights should listeners take away from this significant clash between big publishing and big tech?
First, the alleged use of shadow libraries like LibGen by a major tech company underscores a critical ethical and legal challenge in AI data sourcing, raising questions about due diligence and accountability.
Second, the transformative use defense will be rigorously tested, with the Andy Warhol precedent potentially narrowing its application compared to earlier cases like Google Books.
Third, the lawsuit isn't just about past damages. It's a battle to establish a future market for AI training data, with profound implications for both content creators and AI developers.
And finally, this case represents a pivotal moment in defining the future of intellectual property in the age of generative AI, potentially setting a global precedent for how AI models can and should be trained.
The courts are facing an unenviable task, balancing the imperative for technological innovation with the fundamental rights of creators. How they thread that needle will shape the digital economy for decades.
And for listeners, the questions remain. Can copyright law truly adapt to the pace of AI development? And who ultimately bears the responsibility when innovation runs roughshod over established legal and ethical norms?
That's all for Law and the Machine. Join us next time as we continue exploring where AI and the law collide. If you found this useful, subscribe. We appreciate it.
The law will catch up, eventually.